Ladies and my lords, as an introduction to the criteria that originate from the Christian Brothers case, can I just take the court to the relevant passages very briefly that my learned friend's already taken my lady and my lords to them, but there are two further short passages I would pick up. The background is paragraph 35 at MS 369 in the Christian Brothers case that starts at MS 355 behind tab 2 in volume 1. And the 5 criteria set out in paragraph 35 that I'll address in the order in which they're set out there rather than the order of importance that they've now been recategorized into. The fact that they apply in the cases where there is a grey area as to the status of the tortfeasor and the relationship with the defendant comes from, as my Lord Reid has already mentioned, from paragraph 47 is where we get from the Christian Brothers case the fact that these criteria, because in paragraph 35 they're referred to as applying between employer and employee, but from paragraph 47 we get the relevance of applying them in cases such as this, where there is an area akin to that between an employer and an employee. And the wording there is that the relationship has the same incidence. That relationship can properly give rise to vicarious liability. So that was the test from there. And I mention also, whilst looking at Christian Brothers' case, in paragraph 36, in terms of the significance of control, it's relevant perhaps to this case and to some of the submissions made by my learned friend, that on page 370, it's paragraph 36, but the second half of it, today it's not realistic to look for a right to direct how an employer should perform his duties as a necessary element of the relationship between employer and employee. Many employees apply a skill or expertise that is not susceptible to direction by anyone else in the company that employs him. Thus, the significance of control is that the employer can direct what the employee does, not how he does it. That applying paragraph 47 will apply to the investigation in terms of the middle ground akin to an employment situation as well. And it's obviously particularly relevant to professionals, where the very use of professionals is in order that they do decide what needs to be done rather than and how it should be done, rather than being very specifically directed, because in a sense there's no point in having a professional if you tell them precisely what needs to be done. The other paragraph that I just draw attention to, which is relevant to criteria 1 and the overarching point of vicarious liability, is in paragraph 43. Vicarious liability, the second half from halfway down letter E. Vicarious liability was a doctrine designed for the sake of the claimant, imposing a liability incurred without fault because the employer was treated at law as picking up the burden of an organizational business relationship which he had undertaken for his own benefit. Accordingly, what one was looking for was a situation where the employee in question, at any rate for the relevant purposes, is so much part of the work, business or organisation of both employers that is just to make both employers answer for negligence. That's a reference back to via systems, but it does set out the test and the rationale for vicarious liability. And where one is looking at what is fair and just, one has to always look in terms of vicarious liability at the argument that the defendant can always say it's unfair because it's always no fault, and what one is looking at with vicarious liability is a balance between two innocent parties, as it were, whether the claimant should go without remedy or whether a defendant who has not been at fault should bear liability through the mechanism of vicarious liability. So it's not surprising that it seems unfair to defendants. That's the nature of vicarious liability. So in addressing the criteria, the first one being means to pay, which has, and we fully recognise, has been put in the category of lesser importance, but is the first in the list. In terms of this particular case, it's suggested by my learned friend in the printed case and was said today that, well, Dr. Bates would have been able to pay if he'd been sued at the relevant time. We would say that is a very unrealistic way of looking at what the position would have been, because actually, if you think about it, had these young women felt able to go to the police at the time of the abuse, what would have followed, one would hope, would be a prosecution and suspension of the GMC. And where my learned friend says, well, he was earning well and he would have been able to pay damages, that is quite an unrealistic way of looking at the situation. And it's relevant because obviously it will apply in other cases too, that a professional in the position of whether or not they have insurance, being uninsured in terms of deliberate acts of abuse, will very rarely be able to pay. His first call on his assets would probably have been his criminal defence, rather than paying compensation to claimants. And it's highly unlikely that at any point when he was personally sued, he would have had the means to meet certainly the number of claims that have now come to light, which is well over 100, he would certainly not have had the means personally. And that's where the balance, and that may mean that this case is in the rare situation which is referred to by my Lord Reid, paragraph 63 in the Arns case, which again we've already looked at. Just to highlight that paragraph, it's MS 319 behind tab 1, and the relevant paragraph is 63. In relation to the remaining issue, that of the ability to satisfy an award of damages, vicarious liability is only of practical relevance in situations where the principal tortfeasor cannot be found or is not worth suing, and the person sought to be made vicariously liable is able to compensate the victim of the tort. These conditions are satisfied in the present context. Most foster parents have insufficient means to be able to meet a substantial award of damages, unlikely to have or be able to obtain insurance against their own propensity to criminal behaviour. The local authorities which engage them can more easily compensate the victims of injuries which are often serious and long-lasting. And very similar considerations, we would suggest, apply to a general practitioner who is unlikely to have been able to insure against his own criminal acts, and even if he has some assets at the time of a police prosecution, unlikely to have assets by the end of it, as it were. So this is a case where means to pay may be a relevant criteria, although we wouldn't suggest that it's the main one by any means. It was also explained in the case of Baisley, the importance of the imposition of vicarious liability in order to provide a just and practical remedy. If I can just refer to that case at tab 10 in volume 1, MS 621, is where it starts. At paragraph 30, MS 640, obviously the left-hand side of the page, if English is the right language. Page 640, paragraph 30, the policy in halfway down that paragraph, the policy interest embraces a number of subsidiary goals. The first is the goal of effective compensation. One of the most important social goals served by vicarious liability is victim compensation. Vicarious liability improves the chances that the victim can recover judgment from a solvent defendant, and there's a reference there to Fleming. So the appellants in this case complain that the application of the first criteria gives rise to a potential for injustice for the innocent defendant, but as I say, unfortunately, that is always a consequence of the imposition of vicarious liability. In any situation, the defendant can complain there's an injustice because it is assumed that they are innocent and not responsible for the acts, but only responsible on the basis that they have embraced the tortfeasor into the organisation in a way that gives rise to vicarious liability. Then moving to the second criteria, which is of more importance, that the activity taken on by that debate was an activity taken on behalf of Barclays. And it's perhaps relevant for those purposes just to look briefly at what is said in the master defence, which is in the core volume at MS 158. Paragraph 3, at all material times, the defendant engaged registered medical practitioners to carry out pre-employment and medical examinations on prospective employees. Appears from the limited documentation still available, the purpose of such medical examinations was so that the defendant could be satisfied that the individual concerned was medically suitable for service in the bank and was recommended for life insurance at ordinary rates. So the purpose is clearly for the appellant's purposes, and it's perhaps also relevant in that regard to look at what was said in the case of Exon Bedfordshire about the role of an insurance doctor and who the doctor owes duties to. That's in Bundle 2, tab 20, at MS 1045.
So the page number, sorry?
I'm sorry, 1045.
1045, thank you very much.
At letter H. This is the speech of Lord Brown Wilkinson. It's in the context of looking at the duties of social workers and psychiatrists, but at the bottom of the page, or starting at letter G, like the majority of the Court of Appeal, I cannot accept these arguments. The social workers and psychiatrists were retained by the local authority who advised the local authority, not the plaintiffs. Then right at the bottom, the Court of Appeal drew a correct analogy with the doctor instructed by an insurance company to examine an applicant for life insurance. The doctor does not, by examining the applicant, come under any general duty of medical care to the applicant. He is under a duty not to damage the applicant in the course of the examination, but beyond that, his duties are owed to the insurance company and not to the applicant. So that in carrying out the examination, to say that these examinations were carried out for any benefit for claimants themselves is not, we would say, how the courts have looked at this type of examination. There is another case, R and Croydon, that we haven't specifically referred to, of a health check for a nurse where a heart defect wasn't picked up, and the courts found that the health examination was only for the benefit of the hospital as to whether to employ her or not to give her advice about her own health. So it is right to say the background of the activity taken on by Dr. Bates was truly taken on behalf of Barclays, with really no benefits to the claimants themselves. The
Well, other than the indirect one of getting a job.
Well, analysis of that has differed, I think, and I think the Court of Appeal looked at that. The simple answer to that we put is that they could have had the job without the medical examination. The medical examination wasn't the reason they got the job. They were offered the job, and the bank required them to have the medical examination in order to take up the offer. But they got no greater benefit than if they'd been allowed the job without the medical examination. And indeed, it was suggested that later on the medical examinations weren't required by the bank. So to say they got the benefit of getting the job is only because that's a hurdle that the bank put in their way in order to allow them to have the job. So it's hardly an independent benefit to them to have a medical examination.
Was it not related to the provision of life assurance?
Well, it was, I think what is said, at standard rates, which I think means that
Yes.
that it was suitable for service and was recommended for life insurance at ordinary rates. It might be said that if they needed to be, higher rates needed to be paid, then the bank would have an additional burden of paying higher rates if they hadn't insured the people they employed past their medical. So that was to protect the bank from having to pay higher rates for employees who hadn't had a medical, would be one way of putting it. But it wasn't suggested that the bank would take on employees without life insurance. It was simply they wanted to ensure everyone they took on fitted the life insurance criteria. But employing bank clerks without this very detailed medical examination that they were required to do was not, that going through the medical examination was hardly in itself a benefit to those undertaking the examination. And we can see the details of the examination and the circumstances in which they were asked to undertake that examination from the witness statements, which are in Appendix Bundle 2 at MS 182.
If you could give the page number at the bottom of the page as well as the MS number.
Oh, I'm sorry, yes.
Our appendices don't have MS numbers.
Oh, we do have ones that...
If you just give the number when you... It's in the centre of the page.
77.
Thank you.
This is just an example. Many of them are similar. One sees there on page 77, paragraph 5, I was aged around 15 or 16, still completing my GCSEs. And then what happened, I was invited to attend the interview, and then it was clear to me during the interview, she asked me a number of questions. At the end, she offered me the job, subject to me passing my GCSEs and passing a medical. It was obvious to me the medical was compulsory. I was not given any option as to whether I could attend. I had understood that the job was subject to me passing the medical. She told me they would write to me with details of the appointment. I was not given the option of who to see, or asked if I wanted to see a male or female doctor. And then there's descriptions of the examination from paragraph 13 onwards, and the fact that the examination that Dr. Bates did, the claimant was aware was an examination arranged by Barclays, paragraph 17, also very aware that Barclays had arranged the medical. I knew I needed to pass it in order to get the job. I was very anxious to get the job. And at the time, you didn't question adults, in particular, you wouldn't question a doctor as he was in a position of authority. So, page. And there is a description there of what she was required to do by the doctor at that examination. There is also a description which is relevant to the degree of control over what happened and how it happened in the witness statement, which is MS 192, but starts at page 87. On page 88, paragraph 8. Paragraph 7. I think I attended the interview in around June 1977. Paragraph 8. I needed to come to the head office in Percy Street before attending the medical examination. Went to the head office in Percy Street, was given a sheet with written instructions to attend a medical examination with a Dr. Bates. I was given the bus fare by Barclays, and they gave me directions as to where to go for the medical, instructing where to catch the appropriate bus. It was all arranged by Barclays. I was told the doctor would report back to Barclays following the examination. Not given a choice as to which doctor I could see, I understood I would only get the job if I passed the medical examination. I believed it was compulsory to attend. And then again, descriptions of what she was asked to do when there, and understandable anxiety about what she was asked to do. Page 90, paragraph 23, very upset and embarrassed by the whole experience. I felt very uncomfortable. I did not think it had been conducted correctly. However, I was a young, naive girl, did not feel able to challenge Dr. Bates. He was a doctor, and I trusted that he was doing what he was supposed to do. I was also very keen to get the job, felt challenge him in a position of authority or say something could affect that. After the appointment, I got the bus back home, never told anyone about what had happened. There is then, whilst we're in this bundle, another witness is able to, the witness whose statement begins at page 97, or MS 202, again was 15 when she applied for the job, has kept the correspondence and exhibits a letter at page 103, MS 208, as to how the bank presented the need for the medical examination. Further to your application for a post on our staff and your recent interview at this office, we write to advise you that we foresee being able to offer you a vacancy this summer. As a first step, we would like you to make arrangements to have you medically examined by the bank's doctor in Newcastle, and if you will advise us of the days on which you have examinations, we will attend to the necessary details at this end. So that was how the applicants saw the need for the examinations. And yes, of course, we accept they got the benefit of getting the job if they went through it, but they could have got the job without having to go through it if that had been what the bank determined. It may be reasonable that they required medical examinations, but the manner in which they they did them, and the integration of this doctor as being an activity taken on behalf of Barclays is clear. The difference with a medical examination carried out in these circumstances to what a young woman would normally expect of a medical examination is that they go to the examination not knowing what to expect or what part of their anatomy needs to be investigated or examined. Normally, a young woman going to a doctor would say, I've got a sore elbow, could you please look at my elbow, and has control over what examination is carried out and has a benefit from it of getting treatment for that illness, a prescription, an advice or a referral. These young women didn't get the benefit of a normal medical examination in the sense that they were entirely healthy when they attended, and they knew not what to expect by way of the examination. They simply had to comply with whatever the doctor asked in terms of the examination. And we see the form that was provided, that's referred to in the young woman who attended at Percy Street, was given the form at page, in the same bundle, page 190 onwards, MS 295-296, is a completed medical examination. It's the one that is referred to in the Court of Appeal judgment as referring to normal external genitalia on page 191. In the question that was asked in respect of female applicants only, in terms of their menstruation and their history of miscarriage or other matters. And certainly with the eyes of today, and I would suggest even with the eyes of the 1970s, one wonders why this medical examination form had to be quite so intrusive and extensive for the purposes of providing services as a bank clerk. The relevance of asking questions as to whether a young woman had ever had a miscarriage and taking chest measurements for doing a bank clerk's job, and the descriptions of their physique and a huge amount of detail, which will have been alarming to them to have to give an answer on an examination that was required, we would say, only for the bank's purposes, not certainly for any medical benefit to them or medical purpose for them.
What's the date of this form?
I think it's
December 1982, is it?
that one. There are a range, and I think it's dated at the bottom, 13th of December 82, yes.
Yes.
Yes,
So-
the passage you refer to for female applicants only, that comes under the form heading of personal history. Examiner to make inquiry into past or present medical history by asking the following questions. So it wasn't instructing an examination of that matter. It was instructing the examiner to ask questions.
Yes, and we would say that comes under which is why I referred to the passage in relation to professionals, that with professionals you may instruct them what to do, how to do it, and the detail that you do, you expect them to use their own discretion. We're not saying, of course, that the bank instructed the doctor to do anal examinations. We're saying the bank gave the opportunity by asking for such a detailed and personal examination of young women unchaperoned, sent.
Well, I understand that, but just to look at what the bank was asking for, on page 1 and 2 was a request that answers be obtained to questions. Page 3 and 4 was the report on the appearance of the young person, which itself involved some degree of intimacy. Yeah.
Indeed.
Yes. Thank you.
There was then the asking for, which the doctor interpreted as a question about physique and chest measurements and other.
Yes.
And
This form that we're looking at, of the 13th of December 1982, the response given to the paragraph, or subparagraph 5, female applicants only, is that representative of the forms that have become available to the claimants?
well, we have only a limited number of them, unfortunately, and I think that's the only one that is as explicit as that. But certainly there are quite
One might want to consider whether, whatever the intention of the bank in composing the form as it did and giving the instructions that it did, if it was conscientiously reading the forms, and this was typical of the answers given by Dr. Bates, it certainly would have come to their attention that intimate examinations were taking place.
Of course, but that might go to allegations of negligence, which are a separate part of the...
Well, it goes to allegations of negligence, but it may also go to the question of control and risk.
It certainly goes to raising the risk, which is where we rely on it, and I'm coming to that. I'm sorry, I've probably gone a bit ahead of myself, trying not to go backwards and forwards in the bundles. But
yes, that's all right, but come to it when you can.
But it also, we would say, goes to the activity being taken on behalf of Barclays, because they have asked for these questions to be answered for the purposes of their medical examination. The forms go straight back to them. They don't go to the claimants. They go back to them with all of this personal information for their files to make what they want of. And they, the form is headed as a Barclays Bank form. We don't, as my learned friends say, know who drafted it or when, but it's certainly adopted as their medical examination form and sets out the requests that they make of what they've referred to as their doctor, and that's how the claimants understood that they were going to see the bank's doctor and should comply with whatever he was requesting by way of a medical examination, as they themselves describe themselves as naive 15-year-olds. Some of them, I think, describe how they're still playing with dolls, and they're very young women doing their first job. They are children, and they are sent on their own, and that's why I referred to the paragraph of the young lady who was asked to go to head office. She was given the form and the bus fare and an imminent appointment, no chance to go home and say, can my mum come with me, or anything like that. Days before mobile phones, a young lady turning up at head office, given her bus fare, told it's the house down the road, you've got to go down there for your medical now. They are totally reliant on the bank having arranged that in a responsible way. So there was no choice, and although there is some suggestion that the bank may have had other doctors who were used from time to time, though it is, I think, accepted that it was Dr. Bates who carried out almost all of the medical examinations. The only evidence we have in the bundle of anybody having a different medical examination, I think, is Dr. Bates's own son, where he says it wasn't appropriate for my father to carry out my medical examination, so they found me a different doctor to go to. So the medical examinations were, we would say, certainly an integral part of the bank's recruitment process. They wanted the medical examinations carried out, and they sent the young women. They made it a condition of the recruitment, and they determined exactly when they made the appointments, and they sent claimants on the bus to the house. They knew the appointments would take place in the doctor's own private home, and made no arrangements for chaperones, and many of the statements describe the claimant being alone in the surgery. Others describe that they think his wife answered the door. It's not on every occasion they were alone in the premises, but there were certainly occasions when they were, and that was the arrangement made by the bank. And the type of examination was an examination designed for the bank's purposes and for no other feasible medical purpose. So the criteria 2 and 3 overlap quite considerably, that the activity was taken on behalf of Barclays and that the activity was part of the business of Barclays. We would say it's, and the appellants do say this, well, he wasn't a banker, so how was it part of the business of banking? We say that's a rather simplistic way of looking at the business of a large high street bank. It must require healthy bank clerks who've got to be carrying out the bank's business of banking, and it requires an HR department, probably a cleaning department, all sorts of different departments. It doesn't really sit very well with the criteria of part of the business of Barclays Bank to say that that is restricted to banking. It clearly can't be restricted to banking, and they can't only integrate into their business someone who is a banker. And obviously, in some circumstances, a large organisation will have a doctor who is on the premises and is directly employed by them. That's one model. This is very close to that model in that it is the same doctor, that the claimants are sent to that doctor with their form and their requirements as to the examination, and it is simply that the doctor was paid for each examination. There's no suggestion he was paid differently for longer or shorter examinations, or that he had any business interest in doing a longer examination or doing an examination any differently or a repeat examination. He was simply paid on a piece basis for each of the examinations that Barclays wanted done. There's no suggestion he ever had the opportunity to say, no, I'm only doing 2 this week. He did, as far as we can see from the information we have, all those examinations that were sent to him. And the business of recruiting depended in the model that Barclays designed for recruiting young bank clerks in this period for over 20 years, involved using this doctor for their medical examinations. And that is, we would say, incorporating Dr. Bates into their business model. So that in professional and business context of the 20th and 21st century, it's a range of circumstances in which one person carries out tasks at the request of another, and the model of having a doctor off-site who conducts all of your medical examinations fits in the model of somewhere between independent contractor and direct employee, and we don't suggest it's a direct employee, but it is very much closer to that than an independent contractor who is building his own business and providing a service that is designed by him. And obviously one difference in the bailiff's case that my learned friend referred to was that it was pointed out there that there was not any respect whatsoever in which the way in which debts were collected was designed or described to them. There wasn't any respect whatsoever, whereas here there are very clear respects in which the way in which the medical examination was to take place was designed, because all the questions on the form were expected to be answered. So the creation of risk is stark, we would say, in this case, because Barclays was sending young women for an examination over which they had no control and didn't know what to expect. And that is a very important aspect that distinguishes it from saying, go to your own doctor and get a medical examination that says that you're fit so that we can offer you the job. It was very different from that, and it was raising the risk in a way that a medical examination normally wouldn't do, in that whilst they were surprised and uncomfortable by being asked to remove their clothes, particularly in a small room with a window, and to lie on a couch and to have anal examinations, they didn't have any means of knowing that that wasn't what Dr. Bates had been asked to do. They simply were told, he's going to do a medical examination that we require for you to get the job. They believed he was the bank's doctor because that's what they were told. I'm not suggesting that that makes him, that in any way determines his formal status, but it is the message that they had when they went there, which clothed him with an authority that, and it does make a difference, because it may also make a difference as to whether what happens is reported. If they believe he's the bank's doctor, they're looking for a job with the bank, it's much less likely they're going to come back and say, your doctor did things we don't think we should have been asked to do. One would hope nowadays maybe young women would, but these, and very many of them that we now know, didn't. They didn't challenge it. They thought the bank required them to see this doctor, and that's what they had to do, whatever he asked them to do in the course of the examination. So he wielded an unusual amount of power over them in the way that a family general practitioner wouldn't do, because family general practitioner you would go to at your own whim for your own purposes, and you'd know what to expect in terms of, you would say what was wrong with you, and you would ask him to examine what you wanted him to examine. It's the lack of power as to what he was going to examine, and the fact that they believed that's what they had to do, that we would say very starkly creates the risk in this case. It created a risk which is starkly borne out by the events. The fact that all of these young women that we are now part of the group action for the claimants accepted that that's what had to be done by way of the examination is perhaps a stark example of what the risk was. So that the further criteria in terms of control, in this case there is far greater control over the activities of Dr. Bates than would normally be of an organisation over a doctor. But I say that with the proviso of what I've already drawn attention to, that in terms of professionals, there is normally quite a wide area of discretion, even for formal employees, in terms of direction as to how their work should be carried out, because what you are paying for in employing professionals, even in a formal employment sense, is their own expertise, their own professionalism, and their own idea of how best to carry out a task. So you don't expect an enormous amount of direction, even for a formal employee, in terms of control. But here, as far as medical examinations were concerned, there was more control than one would normally expect, in terms of the forms being very lengthy and by definition requiring the doctor to spend quite considerable time with the claimants in order to achieve answers to all of the requests that were made, incorporating a need for chest measurements that certainly those couldn't be carried out without close contact with the claimants in order to carry them out. The appellants complain the correct analysis is the bank didn't specify the nature of the examinations, but only the matters on which it wanted Dr. Bates to report. It was up to him to determine what examinations to perform and how to conduct them. Well, that may be, that's the appellant's case, paragraph 72. That, in literal terms, is right, that they determined what examinations to perform, not how to conduct them. But that goes to raising the risk in that by asking for the examinations that they did ask for, they were leaving it to him as to how to conduct them, because that's what you would expect to do of a doctor. You wouldn't expect a doctor to be told what type of tape measure to use or what type of gloves to use for examinations, or to be any more specific than this form was. The form was about as specific as a medical examination form would ever be, in terms of prescribing what was required. And the examination of the respiratory system, Dr. Bates was directed to separately examine for chest formation, percussion, notes, breath sounds, and in relation to the cardiovascular system, directed to examine separately for pulse rate, position of apex beat, heart sounds, heart murmurs, and blood pressure, all of which would invite physical contact in order to do them. And one does wonder, on looking at those requests, really why the bank would need all that in order to obtain insurance, or in order to decide that a young woman was a suitable candidate for a job. So the witness statement...
Is it known whether the medical forms were created by the bank or whether they were created by an insurance company and then given to the bank?
We don't know the origin of them. I think what is said is that I think the witnesses inherited them from the days when Dr. Bates was, or they inherited Dr. Bates from the days he worked for Martin's Bank, and they simply carried on who designed the form is not apparent from...
Well, some at least of them are headed Barclays Bank, aren't they?
Oh, yes.
They're all headed Barclays Bank.
Yeah.
The logo, one sees the history of the logo through the forms from...
Yeah. I fully accept that Barclays will have produced the forms, but I just wondered, you might have expected, if it was insurance related, that Barclays would consult their insurers, find out what the insurers wanted to know, and then give them the answers in order to obtain standard rate insurance. But if we don't know, then I won't take up your time.
It's certainly not part, or it's not, as I understand it, part of the appellant's defence that they had to provide these forms because they couldn't get insurance unless they asked the doctor to, and one would expect if that was the case, or if it was known to them, that that might be part of their defence, that we didn't ask for these detailed examinations except that was what was necessary because our insurers required it. That's not been said as far as I'm aware.
Thank you.
It doesn't sound as if it was the bank's insurance. It sounds as if it was a insurance for the employee.
Well, it's pretty unclear what insurance they're talking about at getting at normal rates. I think there's some reference to life insurance, but it may also be, they say in the defence life insurance at ordinary rates. There's also discussion of pension plans and further medical examinations that were...
Somebody behind you wants to attract attention.
Sorry.
Well, I was rather assuming that this was that life assurance or pensions were a part of the conditions of employment and would be provided by an insurance company, or that at least the bank would take out life insurance for the benefit of the employee as part of the remuneration package. But I may be wrong, but that's what one would expect in the circumstances.
It may be.
Yeah.
I think this...
On the form itself, the doctor is asked to answer two questions, one of which is whether he would recommend the person is examined for life insurance at ordinary rates.
Well, that would be right. But whether the detail on the form was required for life insurance, again, it's hard to see why necessarily they would need to know about the menstrual pattern of young women. Maybe they did, but it's not. I'm sorry, it's not clear that. Yes, I'm being told that in the employment contracts, there's no mention of life insurance as a benefit. But again, we don't know the details of that. We do have...
I'm sorry for raising it with you. If the facts aren't there, then that's fine.
We have the brochure, which is of some passing interest, at page 144, MS 249, as to what kind of work and where to apply for jobs. And I think they have the description of looking for two types of young ladies, those that just want a little job before they get married and those who are looking for a career. It's explicitly described in the form, which comes as rather amusing to us nowadays, but it was obviously something of the age.
A different age, yes.
But that's the limited amount of information that we have in respect of that. What does that say? Yeah, I mean, all that the brochure says that you will need to satisfy us of your fitness. It doesn't specifically, I think, anywhere describe how you will have the benefit of life insurance.
No, thank you.
And we don't. Nobody says that they specifically benefited from that or provided to them. So that's the way that we address the criteria. Can I just then take my lady and my lords to the printed case just for the other matters that are dealt with in that? It's in the core volume MS 70. And we deal there with the appellant's submissions, but there is a section that I haven't referred to specifically, which sets out some of the history in relation to employment and independent contractors. I wasn't going to take the court to the cases. I think we've set out how we understand the history in some detail in the printed case, and we do say that this is, as far as employment and quasi-employment and akin to employment relationships are concerned, it is an area where the law is rightly moving in order to catch up with a modern interpretation of the very different relationships from that of the old master and servant, and needs to have a wider interpretation of where there should be vicarious liability, and that the essence of it should ultimately be a just, fair and reasonable test, but it should depend on looking at how closely the tortfeasor was involved in the business and whether it's fair in those circumstances that there should be vicarious liability. That is a exercise that was carried out by the judge and carried out again in some detail by the Court of Appeal. And we obviously submit that the Court of Appeal carried out the proper exercise in seeing what was the fair result in those circumstances, given the particular facts of this case. And we don't suggest that the suggestions that this will mean that anybody who asks a medical practitioner to do an examination for any purpose connected with their business is suddenly going to be vicariously liable for medical practitioners. And the Court of Appeal dealt in some detail with the fact that a solicitor asking for a medical examination for a claimant in litigation, could they be found vicariously liable for a medical expert? We would say that is a very long way away from this situation, where effectively the bank had a doctor that they required all of their young employees to see in circumstances which created a specific risk. A medical examination on a one-off basis for an expert who has obligations to the court and is doing a medical examination where the claimant knows that it's their particular injury that he's required to report on, and is given some choice as to who the medical examination should be carried out by, will see the report that he provides at the end of it is a very, very different situation. And to suggest that this, there being vicarious liability in this situation opens up, for want of a better word, a floodgate to responsibility for everybody who ever asks for a medical examination for anybody else to be vicariously liable, is a very long way from the very specific facts of this case and the reasons why in this particular case it's fair, just and reasonable that Barclays Bank should be responsible for what happened to these young women when asked to undergo medical examinations in order to get employment with them. I'm well ahead of time, I think, and
Very good.
I hope that's pleasing. Unless there are other matters that we have, I hope, addressed the other matters in the printed case.
Well, we never take you not to have abandoned anything in your printed case just because you don't happen to have referred to it.
Indeed.
Mr. Carroll? Lord Fox.
My lady, I wonder if I could start with where my learned friend finished, when she invoked fair, just and reasonable as an approach to this case. At MS 81, in my learned friend's printed case, paragraph 513. They deal with what they describe as the unsustainability of an independent contractor defence. And they say quite reasonably that there have been some changes since the 19th century. And then, moreover, coming to the bottom of the page, the law on vicarious liability has moved away decisively from a formalistic approach and towards an approach that emphasises the overriding precedence of legal policy. The relevant policies are capable of applying in principle to those who are independent contractors in the same way as employees. That also includes the overarching policy of ensuring that the law on vicarious liability is tailored in such a way as to provide a remedy for sexual abuse, where that loss should be borne fairly by the defendant. And there is then in the next paragraph, it says, it's presumably in the light of the foregoing, that the appellant is driven to concede that the independent contractor defence is no longer sustainable. And we don't make that concession, my lady, just to be clear about the matter. The argument goes on. The appellant now accepts the defence should not apply to all types. It's expressly conceded, positively advanced, that defence does not apply to those linked under the gig economy. With respect, that mischaracterises the submission that we make, which is that we say that the independent contractor answer still remains the law. What we do say, however, is that if one looks at the particular facts of a case, perhaps a gig economy type case, it may well be that in truth they are not independent contractors, and therefore they will not be able to avail themselves of that answer to a claim in vicarious liability. And the policy, which is referred to in 513, is also repeated over the page at 516, where my learned friends refer to the case ignores the overarching policy objective of providing a remedy for victims of sexual abuse in appropriate cases. It seems to be a suggestion that there is a general policy to provide compensation for victims of sexual abuse. While one can understand that in appropriate circumstances that is entirely right, the cases don't, in our submission, say that there is a special rule for victims of sexual abuse, and I've taken the court to the various passages in that respect. And although the learned friend referred to that one Canadian case, which itself was quoting an academic article to suggest there might be some general policy of this sort, if one looks at the passages I referred the court to in Lister, they very much moved against a general policy approach to this, but favoured a much more structured, legally analytically sound approach to this by developing cases in accordance with precedent. And we submit that it's wrong to invoke a general policy of this nature. My learned friend made a number of points about the way these examinations were arranged and the degree of control that Barclays was said to exercise. There were times when I think what my learned friend was really saying was that there was control over the complainants or the plaintiffs. Of course, the relevant control for the purposes of vicarious liability would be control from Barclays over the doctor, not of the claimants. There is also a danger, with great respect, in assuming a great deal of hindsight about this. We know, as a matter of fact, that Dr. Bates, if the allegations are true, gravely abused his position and did so, as it alleged, on a considerable number of occasions. But, of course, the fact that Barclays gave him the opportunity to do that because of the arrangement of an examination is not of itself, we submit, proof of the necessary relationship which negates the normal answer of independent contractor. The fact is that with a less detailed pro forma, with no pro forma, with an examination by a doctor in all sorts of circumstances, it is perfectly possible for a determined doctor to abuse claimants. The fact that many of these were young, the claimants were young women, and we absolutely accept they were young women without much experience of the world, made them particularly vulnerable. I do accept that. But of course, they weren't all young women. Some of them were men, and some of them were not so young women. But I don't in any way say that that is not the position. We know also that, for the most part, it was Dr. Bates who was the doctor that they were told to make an appointment, or appointment via his wife with, rather than other doctors, although there is some suggestion. And the problem with this distance of time is it's unclear. There was some suggestion that there were some other doctors involved. We don't know, for example, whether he ever turned down particular opportunities. My own friend says very strongly that he didn't. We knew that he had other things. It's difficult to think that if he had more profitable work elsewhere, he would have always taken these. One doesn't know. And similarly, in answer to the question from my Lord Hodge, we don't know precisely about the provenance of the form. It certainly has the Barclays logo on. Whether it was something passed on by Martins and then the logo is put on it, whether it originated via an insurance company, I'm afraid is lost in the midst of time.
Does it matter?
Well, we say that it doesn't matter. But my learned friend made a great deal of the fact that it was a very detailed, a detailed plan, a detailed pro forma, and in particular pointed to the one form which is a part of the appendix to which the court's been taken. I wonder if I might briefly return to that. This is Appendix Part 2, and before I do so, it might be helpful if I took the court to the statement of Margaret Glendinning, which is, the numbers I have are in the middle of the page, which are 106, which is, I think it's MS 211, I've been told, but mine didn't come that way. So it's 106, Margaret Glendinning, who was one of those responsible for organising the medicals, although she retired as long ago as April 1989 and doesn't remember everything, unsurprisingly. She describes the process whereby, when recruitment was going on, and I'm looking at paragraph 9, interviews took place, candidates were filtered out, and then they'd receive a standard letter if they'd been unsuccessful, and then paragraph 12, they were sent a standard letter subject to satisfactory O-levels. They'd normally wait for O-level results to come in before sending a candidate for medical examination, no doubt not wanting to waste the money, and there was a fee payable. And then at paragraph 14, after the medical had taken place, Dr. Bates would return a standard form report back to us, completed and signed by him and the candidate. I would read the forms, and if the medical was satisfactory, then I would pass the forms on to the clerks. The clerks will put a copy of the completed form on the personnel file. I was not involved with the filing or copying process. And then if we go on, we see this is the second copy, in fact, of the same document, but it's page 114, where there is this question and answer which was fastened on by the Court of Appeal and also by my learned friend. And we respectfully submit that if one looks at the form, actually there is a question rather than an examination that's mandated by this. The question being, have you suffered from dysmenorrhea or other menstrual disorder? And whereas mostly it's no in answer to the various questions, this is yes. And the particular claimant describes delay in the onset of puberty. There's also a note that this apparently was a family characteristic. And then it says normal development of secondary sexual characteristics, normal external genitalia, no evidence of endocrine disturbance. Now, whether or not that was an over-intrusive or unnecessary inquiry, that may well be arguable, but it was actually a question which no doubt was considered by somebody to be relevant in terms of a long-term employment or for life assurance. And although we don't know this either for certain, the likelihood seems to me that life assurance would be for the benefit of the employee rather than for the benefit of Barclays. Be that as it may, we submit that may be a detailed pro forma, but what it does not do is, as it were, invite a doctor to abuse his position. And one must not, with great respect, be influenced by hindsight, knowing that that's what happened, to say that this was, as it were, something waiting to happen because of the detailed pro forma. And nor can the question of whether there should have been some more alertness on the part of Barclays, looking at what was said in a particular form, or indeed any other forms that were available, be relevant to vicarious liability, because, of course, vicarious liability is based on the presumed innocence on the part of the bank. If there is negligence, then that is a separate matter. The fact that Dr. Bates was the main doctor, if not the only doctor, certainly the main doctor, appears to be used in this area. It was only in this particular part of the country that he was used. The other doctors were used in other parts of the country. He wasn't the bank's only doctor.
Well, there was one north of the Tyne and one south of the Tyne.
There was, and there were other parts of the country too. Your lady's quite right. Would it make a difference, I ask rhetorically, if there was, say, a panel of 2 or 3 or 4, and Dr. Bates had been selected? Would that alter the fundamental analysis of law? We say, no, it would not. The fact that he is described as the bank's doctor, we submit is an expression and no more than that, whereby Mrs. Glendinning or whoever was communicating with the employee was simply saying this is a doctor who has been chosen by the bank, but doesn't, as it were, decide whether or not he is employed by the bank or his relationship is akin to employment. My learned friend spoke a lot about the fact that he had a number of different jobs. He had a portfolio of jobs. That's quite correct, and indeed said that he was employed in various capacities as a doctor at hospital. That's also true, and in those circumstances he would have been properly employed at the hospital. We entirely accept, and that a doctor employed at a hospital, the hospital would be vicariously liable, for example, for any negligence on his part when working at the hospital. But it is quite possible for somebody to be both a Schedule E employee, such as in the position I presage, and also have Schedule D type independent contractor obligations or services provided, which we say is the proper analysis of much of what he did, and in particular what Dr. Bates purported to provide to those seeking employment with Barclays. The piecework is a rather much a term of art. My learned friend used it. I think, in fact, it often used to be used to describe the fact that you got paid for unit of work rather than because you were only working part-time. But we also accept that part-time employment may be, as it were, employment in the traditional sense, albeit that it isn't a full 5-day week. And there are suggestions, of course, that the 5-day week is going to be reduced to a 4-day week in certain circumstances. Wouldn't change the nature of somebody being employed. The suggestion was that we were taking an over-technical approach to the status of an independent contractor, and that, in fact, the law has moved on from such a technical approach, and it was advanced that we were very much here controlling and integrating Dr. Bates into Barclays' work. Well, we submit that that is not an accurate statement, that he was, in fact, like many of those who provide companies or organisations with particular services, an independent contractor, just as we say in our printed case, a window cleaner or anyone else who is engaged as an important part, a cleaner perhaps. There may be circumstances in which someone is brought in-house and is properly regarded as an employee, but that is not the case here. And he was, the fact that he did other work, we accept, is not necessarily conclusive on a particular factual scenario as to whether somebody is an employee or self-employed. To that extent, we accept what the learned friend says. But the fact that they have other work may lead to the conclusion that it is more likely, and we say that is the case, that he is effectively self-employed in this capacity and working as an independent contractor. Now, of course, my learned friend makes the point that the foster parents in arms were not regarded as workers, notwithstanding the finding of this court that they were vicariously liable. There are going to be situations where somebody may be a worker for some purposes, but that there will be vicarious liability. one of the reasons that I resisted the temptation to formulate a precise definition of employee for all purposes is because the question that a court may consider may be different. And in the Pimlico Plumbers case, it was one question about jurisdiction of a tribunal. It might be in the Bates van Winkelhoff, it was another question that had to be asked. But here we are concerned, my lady, my lords, with a well-established rule which has existed for some considerable time, whereby, properly regarded as an independent contractor, there will be no liability. It is not floodgates that I invoke, never an attractive submission. But we do say that where there is a well-established law and which pertains whether or not we are concerned with the tort of sexual abuse or indeed anything else, the court should not lightly discard such clear distinctions, notwithstanding a proper examination of particular facts to see whether somebody can accurately be described as an independent contractor. In all sorts of contexts, outside the context of the medical profession or indeed building contractors or any of the other circumstances in which there may be independent contractors. Those involved have organised their affairs on the basis of this well-established rule, or can be taken to have organised their affairs on this well-established rule, whether it be entering into appropriate contracts, insurance arrangements, or the like. And the law in our submission should be clear and certain and should be not easily cast aside. And that, we submit, is effectively what my learned friend is inviting you to do, or is to acknowledge has been done, I think is in effect what she's submitting. We submit that there is no basis for saying that any of the decisions of this court or the Court of Appeal have had that effect. And we submit that nor should they have that effect. And that the Court of Appeal were, with great respect, wrong to simply say that the independent contractor defence had disappeared, and that we simply looked at those 5 factors. Those 5 factors, indicia, criteria, are certainly helpful in those areas where we need to identify a relationship which doesn't neatly fall into either employer-employee. But there was no indication in any of the decisions that we cast aside the independent contractor analysis. Despite my learned friend's best efforts, we respectfully submit that this court cannot avoid the conclusion. Indeed, the Court of Appeal did not really avoid the conclusion that Dr. Bates was an independent contractor. And in those circumstances, that is, we very respectfully submit, the end of the case. If not, for the reasons that we give in our printed case and for the submission, for the reasons I've given in oral submissions, we say that in any event, the court should conclude that there is no vicarious liability on the part of the bank.
Could I just ask you, it's sheer curiosity really, what the state of play on the limitation issue is?
Limitation is an issue in the case. It's been pleaded, and plainly it arises on the facts. The judge selected this particular issue as a preliminary issue. Of course, on one view, it may put an end to the litigation. Depending on the outcome of this case, it may not put an end to the litigation, but limitation exists and we rely on it in our defence.
Yes, you clearly, I've been looking at the pleadings and it's clearly pleaded. I just wondered whether it had actually been overcome in some way, irrelevant for the purpose of this particular issue, but no, this issue was identified as a preliminary one before, possibly identifying limitation as another preliminary issue. Yes.
It was a group action.
It's a group
action. A number
action.
of issues, and the judge decided that she would presumably be helped by the determination of this issue. Unfortunately, her decision didn't help our side, but...
Very well. Thank you all very much indeed. Well done, both of you. Yes. we're always pleased when people do not let the work expand to fit the time available. And we will now, with the benefit of your very helpful arguments, go away and try and work out what the answer is. Court will now adjourn.